Gauri, you can start.
Good evening, everyone. I, Gauri Budhiraja, on behalf of the team of Asia Pacific WIS Pre-Moot, welcome you all to today's panel discussion, Getting WIS Ready, Here the Coaches. What makes the second Asia Pacific WIS Pre-Moot unique is that it's one of a kind and inclusive of everyone's participation. The ideology behind this moot is to step out of the ordinary and provide exposure for holistic development and learning. It is an exciting competition that aims to give training to young budding lawyers and students to improve their skills in advocacy and arbitration. This pre-moot will be an essential part of training for students and arbitrators planning to attend the WIS moot and WIS East moot. The skills learned here will also be a key component for future careers in arbitration. Today, we have with us Dr. Ajay Rab, who shall be the panelist and the moderator of this session. Dr. Ajay Rab is a partner at Rab & Rab Associates LLP Dehradun and an arbitrator. Dr. Rab is an adjunct professor at the National University of Juridical Sciences, Kolkata, visiting professor at the National Law School of India University, Bangalore, and visiting faculty in other law schools in the country. He is also a pioneer member of the Asian Institute of Alternative Dispute Resolution, Kuala Lumpur. We have with us Ms. Nadine Pfeifner, an associate with Rothen Legal, a dispute resolution boutique firm in Zurich. Before joining Rothen, she worked as a lawyer in the litigation, arbitration, and internal investigations department of a large Swiss corporate law firm. She has coached the WIS moot teams of King's College London and the University of Zurich for several years and is also one of the coaches of the current University of Zurich WIS moot team. Besides her work as a lawyer, she's writing a PhD thesis in the field of international and Swiss commercial law and arbitration. We also have with us Dr. Naveen G. Ahuja, an editorial board member of the International Arbitration Law Review, an accredited tribunal secretary at the Hong Kong International Arbitration Center, and an accredited general mediator. Naveen sir is a member of several arbitration-related committees. His notable achievements include his contributions to several publications on the United Nations Convention on Contracts for the International Sale of Goods and Alternative Dispute Resolution. Sir is also the Vice President of the Moot Alumni Association. I'm sure that hearing our experts will give the participants a good start. Ajay sir, I'm sure our attendees are waiting to hear from all of you. I won't be taking up much time now. I welcome you, sir. The floor is yours.
All right, thank you. I was unable to unmute until Mehak finally recognized that it's now time for me to speak. Anyways, I welcome you all and thank you for that introduction, Gauri. It's my privilege to be talking to Naveen and Nadine today on what we know about the WIS moot, how to go about the WIS moot. I believe many of you want to know why we need coaches, because that's a question that comes up. What happens if you don't find a good coach or a coach, let's just say, good is a slightly more subjective analysis. And why is it that all of us are in love with the WIS moot, that people like Nadine and Naveen who've participated in the WIS moot way back in 2011 and 13 are still so invested in this moot? I mean, what makes it so special and how do you go about preparing it, right? So why don't we first hear on what their experience in the WIS moot was, what they learned and how that has helped them, and then get into how to prepare for it. Naveen, would you like to go first?
Sure. Thank you, Gauri and Ajay, and thank you, Asia Pacific WIS Pre-Moot, for the kind invitation. By way of my background, I was in international trade for close to 20 years in a commercial setting, not a legal one. I participated in the Vismoot, as I just mentioned, in 2013-14 during my master's in arbitration at the City University of Hong Kong. As a result of my participation, I had the opportunity to subsequently sit as an arbitrator in the Vismoot. I was coaching our university's moot team for the Vismoot regularly until last year. I had been invited to judge the finals and semifinals in moot competitions, to draft moot problems, and to deliver lectures on mooting. As Gauri mentioned, I got to co-author several articles and book chapters on the CISG. And I made my way to becoming the vice president of the Moot Alumni Association, the MAA. Of course, there are many more benefits of participating in the Vismoot, and happy to discuss that at some stage. Thank you.
Ajar, I can't hear you, but I think now it's my turn. I will just take over. So first of all, also a big thank you from my side for the invitation. I'm really looking forward to speaking about how to get Vismoot ready today and share a little bit of my experience as a former participant and coach. As has been said before, I participated in the Vismoot many years ago. It was 2010 and 11. That was the 18th Vismoot. I was then a bachelor student at the University of Zurich, and ever since I've been active in the Vismoot. So for me, it was an incredible experience. I got to know a lot of friends. I grew personally and professionally through the Vismoot, and as I said, it was just a great fun. And I stayed in it and continued in the Vismoot in the role as coach, also as arbitrator, and eventually this experience also helped me to find my way into arbitration in my professional life. So this is a short summary of the significance my participation in the Vismoot had on me.
All right, thank you. I think it's very clear that the Vismoot kind of shaped both of your careers, right? So I'll cut to the chase. How do you form the right Vismoot team, right? I think there are questions of, do we select based on speakers? Do we select based on how good people are at research? Every university has their own policy of how moots are allotted, all of that. But then what is the process of forming the right kind of Vismoot team? And as coaches, how do you select the right kind of team? I'll go with Nadine first.
Yes. So at the University of Zurich, it's very specific. We also do have a Zurich Vismoot, which is deals with the CISG not the CISG, but the Swiss Code of Obligation and domestic arbitration. So it's very similar, but more national than the Vismoot. And we usually choose participants for the Vismoot from this Zurich moot. But you don't necessarily have to participate in the Zurich moot. We also take other applications. So what we do is we have this mix of people that have already done a moot court, and we have others that apply directly for the Vismoot, and then we conduct interviews with these people. So it's usually the coaches that have the interviews with interested students. And what we do is we try to find out how these people work, and we also let them plead on a case, just give them the opportunity to plead quickly, just to get an idea of how they act. So that's how we do it. It's quite challenging actually for them, but it's not a long interview, but it already gives us a good idea of whether this is a suitable candidate or not. What we primarily also test with questions is how these people work in teams, because I think this is really a very important point. I mean, you will be working in a team for a very long time. It will be intense. And what we try to find out is whether these people actually are ready for this.
Mm-hmm. So the way I understand is the coach comes first and then the coach picks the team. Is that more or less correct?
Yes, that's more or less correct. If we can.
Does it work the same way? Because I know it in India doesn't work the same way. The team comes first and they tend to reach out to people who might be interested in coaching them. So I don't know how that works for you, Naveen.
Oh, that's so interesting that the team comes out first. Because then who actually selects the students?
So at least the universities in India, they go through a similar process as Nadine. They have university internal rounds. And based on the scores, etc., each university has a different policy. Some even have what they call challengers. So if two different teams want to participate at the WIS, they will have an internal challengers. And based on the result of the challengers, they'll get Vienna, Hong Kong, or not get anything at all. So it works very differently. So what are your thoughts on how does the team come about?
Well, I think the starting point is looking for attributes. Mm-hmm. Hard work and dedication, I think, are the key attributes. Of course, everything also what Nadine said, for example, being able to work in a team and so on. Now, the thing what I've found is that it's not uncommon for team members to quit at different stages of the Wismut. Or they stay, but they don't put in the necessary effort. So in order to determine whether the students have the passion, the endurance and determination, it all boils down to the interview process. Ask the candidates why they want to participate in the Wismut, what their understanding of the moot and the preparation for the moot entails, if they've looked at the previous year's moot problem, and possibly even ask them, to perhaps make written submissions or even oral submissions on the previous year's moot problem to really see if they have that passion and determination. Also, perhaps try to ascertain their priorities at the interview stage. So, for example, if it's a close friend's birthday and that clashes with the team meeting, what do they do? Or if it's a Christmas break. Because I remember when I had formed the Wismut team in one of the years, I'm not going to say when, it had 8 members to start with. By the time we reached the oral rounds, there were only 2.5 members. And I say half because the third student had exams and could only attend for half of the training sessions for the oral rounds. So in that year, we hadn't adopted the tips I just mentioned for the interview stage, primarily because we had limited participation interest that year. That said, the team had advanced to the rounds of top 16 out of 362 teams in Vienna. So I'm not going to complain. But about working through the holidays, I just remembered that my wife and I traveled together, and it had been 2 years since we had a vacation. So we took off, we landed, checked into our hotel room, and then suddenly my wife got a work call. She's an arbitration lawyer. And so our weekend went by with my wife on the phone and with me watching snooker on TV and waiting for instructions to go to the business center and collect some printouts. So in preparation for the Wismut, you have to treat it like a real case. You're going against more than 350 teams from all over the world. Thanks.
All right. So the way I see it is, sorry, Nadine, you were saying something?
One point to add to that, and this is, I want to emphasize that as well. What is crucial, I think, when you're a coach and you can choose the team is think about the number, as Naveen said. How many team members do you want to have? And it's also my experience that if you have more than, let's say, 5 people, so we used to have teams of usually 6 actually, but even there it's a bit tricky sometimes, and it's even more tricky if you have more people, like 8. And it's tricky in that sense that you might lose people, because if it's a group of 8, there's always the risk that someone leans a bit back and lets the other do the work, and then maybe at some point you have to kick a person out of the team or not. So yes, thinking about the number of team members is maybe also an important thing to do.
Yeah, I mean, from my experience, I've coached teams that meet till the semifinals and quarters, and they were just 3 members. Right, and 2 speakers and 1 researcher, and then one was like the merit speaker, and the procedural speakers would alternate between themselves. But having said that, it's not that the teams that had more people didn't do well either. But I think the bigger challenge comes when you have more people is who is going to speak and who is going to research. And at some point, if the team coordination is not in sync, then are people willing to take the fall for a speaker who goofed up during the moot? Right? And that's always an issue. So I think when you're deciding on the number of people, I think like Naveen rightly pointed out, what are your priorities? How willing are you to give up your existing commitments? And I think that is something that everybody should possibly keep in mind. But any tips on how people should pick, what is a specific attribute that you would look for in terms of the right kind of memorial or the right kind of way of pleading? Is there some star out there which you can pick? I mean, either of you, whichever wants to take a shot at the star. One maybe key attribute that you think is critical.
Sorry, Ajay, critical for writing a memorandum?
Either way, just, I mean, what would be your, okay, this speaker I have to have in the moot. This person is like, he or she is made out for the Wismoot.
I suppose for me, it would be just persuading me to say yes. If they're already convincing there, for me, it's a no-brainer. I want that. I want to see aggressiveness. I want to see passion. I want to see them just keep trying until, I say it's time to leave. Next person's waiting.
Okay, that's interesting. Would the civil law approach be the same on this?
Actually, yes. If I see someone where I think that's really, this person already has this lawyer behavior and really wants to do the Wismus, really wants to plead, advocate for his client, then if I see that, like a little, spark in the eyes to do that basically and take on that challenge, then I would choose that person. Yes.
Now I'm going to ask you a slightly tricky question. Do you also see that spark when people are pleading before you as an arbitrator? And does that weigh your decision either way, in favor or against the team?
Well, maybe I can go first. I see it often, yes, and I'm happy to see it. It's not that it influences me particularly in weighing, then basically in how I judge on them or give points basically, because there's so many other things I need to consider. But certainly it's a good thing to see. Yeah.
I mean, would you agree with that?
Yes, very much. I mean, seeing that spark and determination is one thing, but really you've got to go through the steps. Your nice introduction and pleading and so on. And it's a team score as well. It's not just an individual thing.
Yeah, so I'll just get to that process then. How do you go with two very different questions. What do you do before the problem comes out? And how do you change after the problem comes out? So either of you, maybe Nadine, would you like to lead on?
Yes. So what we usually do with the team, first, we ask them to attend the Wismut School Switzerland. That's a preparatory week, which was founded and is still organized by Benjamin Gottlieb at the University of Zurich. And it's a week in which different lecturers teach the students on the topics that are relevant for the Wismut. So on CISG, on arbitration, on the they introduce the Wismut rules that are applicable in that year. And then they also talk about oral and written advocacy. So it's an introduction to everything that you need basically for the Wismut. And that's what we ask our team to attend. It used to be in person, so there were a lot of Swiss teams, but also European teams from Europe. And this year it has been online, which I think is a great thing. So there were even more teams from all over the world participating and benefiting from this preparation. And if maybe some of the participants here have attended this school as well. If not, I can really recommend it for next year. So this is one thing that we do. And the second thing we do then in a smaller circle, just coaches and the team, is we have one training session before the problem is released, in which we teach them a bit more about really written advocacy. So what we mainly do is we look closely at a winning memorandum. So we look at the winning memorandum and basically analyze this with the team, show them what are the characteristics of a very good memorandum, and also teach them about the rules they need to apply when they start writing, and which is something we will also talk about a bit later. So that's the two things we do.
All right, Naveen.
I wish I was adopting Nadine's approach, because that's excellent. That just works really well. What we normally do is we actually just present the materials, for example, the CISG text, the model law text, the relevant institutional rules, and also some publications, for example, a summary or understanding of the CISG and so on. But the basic understanding, though, is that they don't read it. I mean, they take it with them, and if they come back the next week, they talk about the first page of the chapter or of the article, and it's obvious that they're not really getting into it yet, and it's okay, because we understand it's just a very beginning. So really what we focus on the side is team building, the relationship. So we get them to talk about each other, what their favorite hobbies are, just meet regularly once a week or twice a week, just get into it slowly. It's a bit of a shame, because you have a few weeks before the mood problem is released. But for me, I think that normally works well, just so that they know more about each other. They look at the past few winning memos, like Nadine does with her teams, just to appreciate what it is that the markers are looking for. Why are they in the top 2 or top 3, and so on.
All right. And so when the problem does come out, I mean, I've had several questions of, I've read Gary Bourne, I've read Redfern and Hunter and all sorts of things. But when you get down to the basic questions in arbitration, you're generally a little clueless. So when the problem comes out and you see drones written over there, what do you do? Do you first start doing a Google search on what kind of drones exist? Do you start figuring out the market for drones, or do you just go straight at permanent court of arbitration? These rules apply. Now I need to just, understand these rules, and then I will look at the problem again. So what is the approach? Because see, the claimant's memorandum can't be done in isolation, right? It's unless you get a holistic picture of what the case really is. So where do you start firing your guns the moment the problem comes up? And Naveen, maybe you can start with this.
Sure. So I think the starting point is to just read the mood problem, understand each and every word in that problem. You should never be in a position where you are asked the meaning of something and you don't have the answer to that. And as you said, for example, drones, you need to appreciate the relevant product or goods in the problem. I remember one year, it was in a pre-mood actually. The problem was about turbines. Mm-hmm. And in the oral rounds, one of the arbitrators had asked about the general size of the turbines. And the student had said it was the size of a table lamp or a table fan, which invited trouble because the size is in fact comparable to the size of an aeroplane. And besides the product itself, you've got to go through the usual routine of coming up with a chronology of events, documents, conversations, note the date, time, method of communication, and so on. It'll help you clarify your thinking. And of course, the dramatis personae, who are all the parties in the problem? What are their roles? And make note if their role had changed any time and when. I think that's about it to start with.
All right, Nadine, your tips on what to do when the problem comes up.
Yes, we do it quite similarly. Also, we tell the team, read through the problem and try to understand it. What is really crucial is also procedural procedural order number one, because therein you actually see what you have to discuss, which issues you have to cover as a team and then address. So this one is basically the roadmap for the memorandum later. But yes, in addition, it certainly helps to Google a bit about the product, to get an understanding of what it is, how it looks like, and what we also often do as an exercise is let the team, once they have read the problem, summarize the case and talk about the case, talk about arguments, even thoughts they have, because often they're even, I mean, as a participant yourself, you realize whether you have really understood what you have read or not. So I think it helps to talk about it and discuss it in the beginning before you actually start go into the details and talk about the individual arguments.
All right, so I have a very different approach to this. I actually tell my teams to make a grid which says facts in favor of the claimant, neutral facts, and facts in favor of the respondent. And once you're kind of done doing that, you realize, and it's a question I've asked nearly every team that I've ever coached, is the problem in favor of the claimant or the respondent? And it's then when you realize where you are weak on facts that you need law to support you, right? And when you can find neither the facts nor the law, you get to the commercials, right? There must be something which logically would not add up, which is why what appears to be in favor of the claimant would actually be in favor of the respondent, right? And that's, I think, a crucial mix in the Wismoot of how do you use the commercials between the parties to really make a point. You know, I could have done it, I would have done it, clause number says so and so, but look at my profit, it would be negligible and it would not make any commercial sense, right? And I think that's one of the larger goals of the Wismoot. Again, I borrow from slight more inside knowledge on this, that if you don't address the commercial aspects, you're probably missing out a big piece of the puzzle, right? And I think that's what I lead with before I have my first meeting with the team in terms of discussing the actual moot problem, right? And that commercials would then involve, like Naveen said, knowing what the product is, what is the market for that product, what is the usual rate of that product, how does one distinguish from one version with the other, and how does that change my profitability? So that's something that I like to do with my team. So, and how much of that goes into the claimant's memorandum, I'm not entirely sure, but then it helps you understand why the dispute has arisen, as opposed to simply addressing it as a moot proposition. So that, I think, ties back to what Naveen had said, that you have to prep like it's a real case. So if you don't understand why I started the business, you will not understand why we are having a dispute, right? So that's possibly, but again, I think let's give some 2 minutes or 5 minutes on what to do and not do in the claimant and respondent memorandums, and how do we distinguish the approach to a claimant memorandum with that of a respondent memorandum. Right? Maybe Nadine, would you like to jump on this?
Sure. So I think many things also that I'd like to address first are the same for the memorandum for claimant and respondent. It's very basic how you start writing a memorandum. And well, the first step is really to also read the Wismoot rules, because there are certain elements that you need to have in your memorandum. So there should be, for example, a statement of facts in the beginning, then you have the main body, you have a summary of the arguments, you have some formal requirements that you need to consider. So this is just basic preparation that you read how it should look like, your memorandum, basically. And then you can already start with thinking about the individual arguments, and those can be legal arguments, but also commercial arguments, like you, Arja, just mentioned, which are also really important. And what we usually do is ask the team to just think about these arguments in bullet points and not immediately start writing, a full text, because it helps to just collect a lot of arguments, even creative ones. It might be that some of the arguments will be kicked out later on, but it's good to have like a full overview in the beginning. And in that thinking process, I think it's important that participants not only think about the claimant's position in the beginning, but also about respondents' arguments. What could they bring actually? What arguments could respondent come up with, and how can we then refute those arguments? So you, on the one hand, have to focus on the position of claimant, but also anticipate arguments of respondent. I think that's an important thing to do. And then once you have these individual arguments, you can think about the structure, how they relate to each other, how you should arrange them. And once you have that skeleton of the memorandum, then it makes sense to start writing and also do some, research is something that has to be done simultaneously, because often it's reading the facts and then do some research, legal research. It's something that you do like at the same time, because one influences the other. Basically, one task influences the other. Because if you read what the legal requirements are, you might get an idea of which facts you need from the case, and you go back to the case, read through the facts, and find the relevant facts. So that is something which has to be done at the same time. Yes, and then I have a lot of points on structure, but maybe Naveen, you want to add something to
just before we get on to that, Nadine, would you also tell us how much of case law is important in the Wismut? Because common law lawyers are obsessed with it. Because because the English court has said it, it's the law. The world has to follow it. And I know, given my civil law background, I understand that civil law works very differently. So when you are in that process of research, do you then restructure your arguments based on a particular case law, or you continue with your own line of thought and just add something from the existing case law? And I think that makes a world of difference on how you then restructure your arguments. Right. So, for example, if we just take Sul America or Enca versus Chubb, if the position has changed, am I now completely redoing what I originally thought about my argument when I'm writing down the memorandum? Or am I just making sure that I use just that authority to support what I have already stated? So, yeah.
Yes. So my approach would be the latter, of course. So being I'm trained in civil law, but I did my master's in a common law country, so I know the two worlds also. And it's true, in civil law we have a stronger focus on the articles, on the provisions. So we would usually start there, think about which articles are relevant, and then look into commentaries. How are these articles how are these interpreted, and what do scholars say on the interpretation of the individual prerequisites? But case law there kicks in as well. So case law is also important because it's also a source of interpretation of that particular norm. So if I have a case which is very important and maybe has really similar facts to the case, to the Wismut problem, to the case I have at hand, then I might put more emphasis on this case, but it's just another argument and just another source that basically supports the argument I want to make. So I would not structure my memorandum around that case, or take this case as the main point, but it's really, it comes in there as well. And the more comparable the case is, then the more focus I would probably put on a case. Also in the past, there have been Wismut problems where there was a particular case which really fit and was very similar, and then you had all the teams talking about that muscles case or that case. So sometimes this happens, but again, I think it's just one piece in a lot of arguments and information that you use to support your argument or claim.
All right, Naveen, your thoughts on the do's and don'ts of a memorandum?
Thanks, Ajay. So for me, the starting point is to go through the mood problem individually. Sorry, my daughters are behind. They just got back. Yeah. For me, the starting point is to go through the mood problem individually. So each member individually goes through the problem as a neutral person, and just note down casually what is in favor of claimant, what is in favor of respondent. Then they put aside the mood problem and then go back to it 2-3 days later, as though they're claimant. They themselves are claimant. They think about what facts are in their favor, and note those down. And normally, when you're doing that, normally you find what facts are against you. You'll find facts in favor of respondent. So you also note those down. Don't dismiss them, because if you're finding things in favor of respondent, eventually you'll have to use them. Then again, take a few days off and then go as respondent. Read it as respondent. And then you'll automatically find things that are useful for claimant. It just seems to happen that way for some strange reason. And then you try to consolidate all the facts that work in favor of claimant. You start a little bit of writing, a few bullet points like Nadine said. And this is pretty much thinking from a business angle, the way Ajay, you also mentioned, like you get your team members to think about in a practical sense, in a business sense. And while they're writing these bullet points and they have these potential arguments, then I get them to go to the applicable legal instruments to think about how to broaden their scope of arguments. For me, I don't like them taking too long to start the writing, because you'd be surprised as to how much of a difference it can make. It's like a written assignment, at university or school. If you wait until the last minute and submit it, you ask yourself, how did I even submit this as a final product? What was I thinking? And these are 35 pages. It's a 35-page written submission. So I normally ask the team to have their memo ready, say 2 weeks before the submission deadline. And from there, the team members can rotate and edit daily. Also, you were talking about authorities. The general guidance we give is that have your arguments supported with mixed legal authorities, case law, scholar, always. Because you don't know who's marking your memo. You may focus a lot on Enka and Chubb, but then if you have a civil law practitioner and he's like, I've just been seeing this in every memo, who knows, right? Although nowadays we're so integrated and the Wismut is so much of a success that we no longer think about, well, that's a civil law practitioner focus on scholars. It's a common law practitioner focus on cases. We're kind of accustomed now to seeing both cases and scholars, which is amazing. But in any case, I normally push for a combination, one case, one scholar. And speaking of authorities, some teams, what they tend to do, or I've seen at least, is that they tend to copy and paste authorities from previous year's memos. And they may be completely irrelevant. Or they may be relying on authorities that are in another language and have no translation. Please, the teams should know that the markers are very aware of this. Also in the memo, the teams should include statement of facts. They should summarize the predominant facts that work in their favor in an objective manner. Make sure, actually, Nadine hadn't finished with the formatting and so on. I'll just finish my one sentence on this, which is that make sure sentences are not too long, 2 or maximum 3 lines per sentence. They should be easy to read and clear. Avoid aggressiveness, rudeness, and sarcasm, otherwise you lose points. This is for the claimant's memo. Thanks.
Yes, all right, Nadine, so I'll let you take your bit on structure and other things that you have in mind.
So I think structure is really key. And then there are several elements that are relevant here. I would say, first of all, the headings are important, and headings are different from headings you have in, for example, in other academic articles or in books, because in the memorandum, headings are often almost sentences. You should the idea is that the arbitrator, just from reading the table of content, understands the main arguments and claims that claimant or respondent makes, so that's the idea. So you have to have headings that are really precise and give away the argument in itself. So this is one thing that is important to consider. And the second one is roadmaps are also very helpful to create a good structure. So once you have the main heading with the main claim, for example, you have a subheading with an argument, for example, and before that, you can have a roadmap which states your claim and then says, for example, claim respondent breached the contract because 1, 2, 3, and you give a roadmap, and then subsequently you actually go into the details of this argument. So that's yes, another important element to create structure. And another point that I wanted to mention is, what else? Structure. There are different rules. They go by different names. For example, the crack rule, or Naveen already mentioned the KISS rule. So keep it short and simple. And the crack rule is basically saying you need to have a conclusion in the beginning, and then you start with the rule. You set out the rule. You apply the rule, the A, to the case. And then in the end, you can have the same conclusion that you had in the beginning, so that it really sticks into the reader's mind. These are all, certain things that you should consider, I think, when writing a memorandum.
That's quite interesting, actually. Have the conclusion first. I personally like that approach, but I don't know if everybody does. So
again, when I say this is just, that's just how we do it, and I've seen it in several memorandums. But of course, there are different styles. So that's important to stress. It's not like this is the one rule, and if you apply it, then you will win. That's not how it works. Yeah.
And I also want to bring this up now because this happened to me very early in my experience of the Wismut. So one participant said, "This is the position of law," and the arbitrator said, "Why?" He says, "Because Gary Bond says so." And the next question actually was the more funny one, which says, "Who is Gary Bond? I've never heard of him." and you could see the student being aghast. You could see the ghost on his face. He's like, "How am I supposed to answer who's Gary Bond?" And therefore, one thing I think we need to be sure of is when we say something that we read from a book, I think we should be mindful of that it's just an opinion, right? And not use it as a position of law argument in either the memorandum or when we're presenting the case. So that's just something on authorities and how to go about it. I think one thing that I really liked of what Naveen said was, don't leave it for the last minute. I know most Indian teams that I've coached, the final memorandum comes about, I think, 2 hours before the submission deadline. Yes, and obviously it has not gone through the sanity and sanity checks, I think, is a better way of putting it rather than sanctity checks. So yes, that's, I think, something that could pick up. And I think I usually advise writing down the argument as and when you're researching on it. Because then when you keep circulating it, what lands up happening is you've also created a draft for, like you said, the respondent side subconsciously. What is it that they would like to attack and how you would like to respond when you have to make the respondent memorandum. I think we have about 15 minutes left. So let's take 5 minutes on the oral advocacy, unless both of you have something to add on memo submissions. Because I have somebody from Iraq asking me, how do you include soft skills in such a short time? And I think that's where the Wismut always is a how do I put it, is a forum for oral presentation rather than what you've written down, because your marks for memorials are not always considered in how good or bad you do at the moot. So would you like to say something on that, Naveen? How do you master skills or soft skills in such a short time? And what those soft skills are? I think let's begin with that question.
I think for oral rounds, there are just a few simple steps, but really, I think you see what we're doing today or this evening or this afternoon is we're giving the teams all these tips, but what we're not doing is giving you shortcuts. So the teams need to bear in mind, all these team members who are here attending, they need to remember that there's no shortcut. It's all extra work in order to succeed. You can find tips everywhere, anywhere, online, Google, YouTube. There are books, articles, there are lots of tips. But the point is that you have to work for it. For example, basic things like research. You don't. So you asked about soft skills, but I think research is critical, because what happens sometimes I find is that team members, they put the research aside and they just practice their presentation for the oral rounds. But really, you don't stop researching until the moot competition is over. You know, 2 days before your session, there may be a new judgment that's out or something that's really relevant. You come across that something really useful for you. With regard to the actual presentation, each speaker only has 15 minutes, 14 minutes for the main arguments, 1 minute for rebuttal or surrebuttal. So first thing you have to appreciate is that you can't fit all your arguments in that little time. Also, you don't know who your arbitrators are. Will there be a lot of questions or a few questions, or will they leave questions at the end of your pleadings? And you'd be shocked to see what's all this, I've forgotten what I've pleaded. So accordingly, you may want to prepare a script. Now, when I say prepare a script, I don't mean that you read something while you're presenting, but rather you have just in a bullet point format, and not even sentences, but rather just words. Just so that, you know, you've done it, you circle it or you tick it, but you put the pen down, you don't keep holding your pen because that causes a distraction. Everyone knows that. So accordingly, you come up with a 4-minute script, an 8-minute script, and a 12-minute script. If you have a tribunal who's just listening to you, ask you a couple of questions, 12 minutes are enough. If the tribunal is not a little bit aggressive, you need your 8-minute script. And if the tribunal is super aggressive, right, you normally see me doing that, you might need your 4-minute script. And things like, even Nadine mentioned in the beginning for the memo, the same thing applies in the oral rounds. You want to have a clear introduction, an accurate introduction, and present yourself properly with a clear roadmap. You know, sometimes in the very beginning, I've heard teammates talk about the facts, the factual background as their introduction, and they make 1 or 2 mistakes, and they're grilled on it. We grill them, and suddenly 15 minutes are up. So you have to be very careful. Anything you say has to be accurate. You cannot make up any facts. I'll just add 2 more points, really. So basically what I'm talking about is, I don't know what kind of soft skills are really needed. What you really need, in my view, is accuracy, clarity, be clear. You need authorities to back you up. You can say anything you want, but when the tribunal asks, why do you say this, or what are you relying on? You need to have an answer, and you can't just say, well, it made sense to me, so I'm relying on it, because you're the counsel. The arbitrator needs to know what the arbitrators have to rely on in order to agree with you. So back your arguments with 1 case, 1 scholar, and have some more as a backup. Your rebuttals, your surrebuttals, you know, that's where you end your argument. So you want to be strong. Remember, you know, normally what happens is you have respondent, claimant, claimant, then respondent, and that last speaker is already exhausted, drained, you know, waiting so long for his turn, starts off strong, and then towards the 14th or 15th minute, they lose their energy. You want to have your energy from the beginning to the end. Remember that your client is behind you, watching you. Your future, your career depends on how you perform with your client watching you. They will introduce you more work. They'll be your long-term client. Sorry, but just one last thing is I love analogies. So whenever I hear an introduction with an analogy, I just enjoy it very much. Thanks.
Yeah, all right, but sometimes the analogies backfire. So you have to be careful, and that's why I think we have coaches, right, to make sure that you don't start comparing apples and oranges.
Yeah.
Yes. All right, Nadine, your 2 cents on what is it? Because I have 2 questions which say, what, apart from arguments and soft skills, how do we make ourselves more presentable and have a good first impression? And the other is about resources while preparing for the Wismoot. So I think maybe you can address both.
So first of all, just 1 sentence on soft skills. I think trust that you will develop these soft skills. Really, you have coaches, you have a lot of support, and as Naveen said, I mean, it's work. You need to practice a lot and exercise, and you can attend pre-moots. That helps a lot. You can have rounds in your team, and with all this exercise, you will develop these soft skills. And there are a lot of tricks. Naveen mentioned already many things that you should consider, and how to structure your pleading, but also, as you said, consider that you have adjustable pleadings. I also like to have just basically argumentative blocks, have a modular pleading. Also, when you respond them, for example, it's really useful if you know that you can just rearrange different blocks of arguments according to the structure the other party already set out. This is something that I like to do, and then also maybe highlight the arguments that are really important. So if you only have 4 minutes, that you don't have to think about, okay, which one am I going to present now, but that you really know, okay, it's these 3 things that I have to portray to the arbitrators. This message has to come across, and then you already know how to deal with this situation as well. So the first question, but then was how to present yourself. Well, there again, Google do's and don'ts in Wismoot, and you will find a lot of lists that give you very detailed information on how to, even dress or behave, or how to present yourself during the moot. I think 2 things that I think are really important. First of all, when you have physical pleadings, then in the finals, think about it. The pleading and the whole presentation doesn't start when you sit there and start your pleading. It already starts when you enter the room. This is really crucial. So arbitrators will be sitting in a room. They will have a look at you, and you already have to have a lawyerly attitude once you enter the room, a professional attitude. I think that's what you should keep in mind. And then you sit there, you start your pleading, and the second important point is I think it's important to own your case. So think about it. It's a pleading. You're acting as lawyer, you represent your client. You're not in an oral exam. It's different from university. So in that sense, again, it's take the case not just as an exercise that you do at university, but it's really like a real case. And this means that once you start, you dictate how you'd like to present your arguments, and also about timing. I mean, even if you get a lot of questions from arbitrators, it's up to you to then say, now I need to move forward. I'm aware of my time. It's these small things that indicate that, you are owning your case. You're presenting now what you need to present. And I think if you show this to the arbitrators, that's a good thing, that you're, in general, you should have a professional appearance, that a friendly attitude towards the arbitrators is important, I think, as well. Even if they ask a lot of questions, it may be even stupid questions in your view, just be friendly. Take it as an opportunity to explain your arguments to them. It might be that they haven't understood something, and then it's an opportunity as well to show that you're professional. But also in there, it's important that you know the facts, has already been mentioned by Naveen as well. This is really crucial. No facts, no authorities, no case law, know it by heart. At that point, the arbitrators to that. And yes, what else? And then again, as you said, the first and the last impression is really important, and just think about that as well. And now I have forgotten about the second question. Sorry, about resources, right?
Yes, about resources, yes.
So what this meant by resources, the coaches.
Some resources that can be used while preparation for Wismoot. So I think that's a large question, but I think I'm going to just suggests that there are, I think, databases and, like you said, Google do's and don'ts of the Wismoot. I think there are also, I think there's something on the Asia Pacific pre-moot web page as well as to what resources you can use.
Yes.
There are just two quick questions, and I'm mindful of, like Nadine said, I'm mindful of my time. Yes, that number one is, do you need one coach, two coaches, three coaches? Does it help to get coaches from different cultural backgrounds? Any quick thoughts on those questions? Naveen?
For me, I like the idea of two coaches, because when you're on your own, you can forget about a couple of things or just forget to include certain things. At least with two of you, it's safer. And if you disagree on something, that's even better, because what you're really doing is thinking about the underlying interest, and that is, how can the team succeed? So if I like something and my fellow coach doesn't like something, we'll argue it. We'll argue back and forth in front of the team, and it will all think about which one was most persuasive and why, and accordingly adopt that.
Nadine, what are your thoughts on one coach, two coaches, three coaches?
The more the merit. No, not at all. Actually, no. Sometimes it's not helpful if you have, like, 5 coaches and everyone says something else. So, and it's in the end, it's also the team that has to decide which arguments they find convincing. I think also two coaches are certainly good. If you can have 2 coaches, that is good. Also for their workload, and it depends on how intensive they coach the team. But it's good to have different brains, and also. Yeah, it's already helpful if you have one person that has gone through this experience and has some experience of the Wismoot, also of the particularities of the Wismoot. So yes, so even with one coach, it's good.
Mm-hmm.
But and maybe one thing also to presentation, that's what I wanted to mention before. If you have more coaches, it's, as I said, it sometimes gets difficult because everyone also has a different opinion on how you should plead, for example. And I think just to be aware, you read a lot of things online or you have a lot of advice from coaches, but I think especially when it comes to presentation, pleading, there are a lot of small things that fall to me in the category of personal preference and individual pleading styles. And there might be someone who tells you don't use your hands while speaking. Others, I like to use my hands as well. It's really your personal preference, and there's no right or wrong in many points when it comes to, I think, pleading. Of course, it shouldn't be distracting, but that's like common sense. I don't think that.
Yeah. So that brings me to my last and final question, which is, one of the objectives of this moot is inclusion, the pre-moot, that the Asia Pacific pre-moot. And I don't know if you've ever had the chance to work with somebody who's has a different kind of ability or disability, and I don't know what the politically correct term for that these days is, but that's the question that I think we need to ask ourselves: is, have we dealt with somebody, or have we ever had the chance to include somebody in one of our teams? And if not, then as coaches, what is it that we can do to ensure that happens? So I don't know if either of you have had the chance. I'm not sure.
Well, for me, when we talk about, presumably you're referring to diversity and inclusion, it really depends on who's approaching you and wanting to participate. I don't see any reason to discount someone because they're different. On the contrary, it's an advantage. So, for example, when I was participating in the Wismoot, I'd actually paired up with someone who was exactly half my age at that time. I'm not going to say how old I am, but so, like, for example, last year we had a year 1 law student participate in the moot as well. She had no idea about contract law, nothing, and I just thought it's good to have people from different backgrounds, because that's what you want. You want to have different ideas from different people, group them up, and then think about what's convincing and what works for you.
Nadine?
Yeah, I think so too. I mean, first of all, it's scientifically proven that mixed teams work better. It might be more challenging at times, but you learn a lot more if you have different kinds of people, and I'm talking about age or gender or background, anything. We had the chance. Well, this year we're not very inclusive as regards gender, not very diverse, because we have a team of 8 women this year at the University of Zurich. That's a first, actually. So
I think that's very inclusive, Nadi.
In a way, it's also, a good thing. I'm happy about that too. We have an Ukrainian girl that fled from Ukraine and is now studying at the University of Zurich. We did have mixed teams in this regard in the past, and we still have it, and I think it's very beneficial for everyone.
All right, thank you for that. I think we've just about hit the clock, and before we start losing our marks for the oral presentation, Mehek, is there any other unaddressed question that you think is extremely relevant to getting ready for the WIS and that we should definitely address it?
No, sir, I think you've covered all the important questions.
Yeah, so I know that there's another webinar happening on the oral advocacy as well. So I've been very mindful of not letting Naveen and Nadine, give their expertise on that just yet.
Very good.
Yeah, but Naveen, you were saying something. I think I cut you short.
No, sorry, I was just thinking of a few pointers for the oral rounds, which is basically, use a mirror, look at how you see yourself, record yourself, just think about how you actually sound, because sometimes, it's very different from what you actually think you sound like. Things like that. Just be a good listener. When somebody asks you a question and then they repeat the question, so the arbiter repeats the question, it's either because they didn't like your answer or they didn't understand your answer. But that doesn't mean that you repeat your answer. You have to think about that. Just be a good listener.
Yeah, so I think that there's one thing that is a sort of a cliche when it comes to philosophy, is that you need to listen in order to understand and not listen in order to respond. And I think that's a fundamental mistake that most people make, is that if a question has been put to you, I need to respond to it quickly and just respond so that it doesn't look like that I don't know enough. And I think that's the fundamental mistake. And I think that's what Nadine was trying to say when we say we are presenting a case. It's a conversation. You're a counsel and the other person is an arbitrator and a judge of sorts, where they are trying to understand your case and you are trying to present your client's case, as opposed to an oral examination or a viva where if you don't answer within 30 seconds, well, you've lost the point. Right. So, and I think that's what is important. And I think the questions are on brief analysis of the issues of the case. So I don't know if Nadine or Naveen would like to address the current Westmoot problem or any tips that anybody has, or are we all staying mindful of our jurisdiction and saying, well, that's reserved for only our teams? Yeah. So I don't know, any big thoughts out there on the current moot problem, or are we just okay to call it an evening and say goodbye and let people work, like Naveen said, work hard on the problem, and we'll see when you get there.
I think so.
Honest,
I think. No, go ahead, Naveen.
I was going to say, I haven't read the moot problem yet. I'm not coaching this year.
This is also something which is really, happens often. Be aware, everyone, that, and I'm sure coaches will tell you, but that's very true, that some arbitrators just read this moot problem on their way to Vienna or Hong Kong, on the plane. So you have much more knowledge than they have, which makes it even more important to take their questions friendly and try to, explain to them what the problem is about, that this might happen. But I think the main problem is it would cover another hour if we start talking about the actual Bismuth problem. It's I think it's a good case, and I just wanted to wish everyone a lot of fun with it, and of course, the best of luck for the whole competition.
All right, thank you. Any last thoughts on that, Naveen, before we say goodbye?
Just work hard, play hard.
That's the keep it short and simple rule, right?
fully agree.
Right. I'm very grateful to both of you for the time that you've taken out. And I think it was a fun conversation, at least for me. And there's some real good tips that I picked up. So I don't know, I'm sure everybody else would have had a lot of things to really think about the way they think about a memorandum or how to write it. And I'm very grateful again. And I hope to see both of you and everybody else on this virtual platform, either in Hong Kong or Vienna. Right. Over to you, Gauri and Mehak. And as you please, you can chop us off, cut us out, as you please.
So since there are no further questions, with your permission, I'd like to conclude the session. Thank you, sir and ma'am. It was an honor to host you. And we look forward to more such future webinars. And we're excited to have the second Asia Pacific WISP pre-moot. I hope everybody across the forum keeps safe. Have a good evening, everyone. I'd now end the meeting. Thank you.
Thank you.
Thank you.
Thank you very much.
Very nice meeting you. Thank
Bye.
you.
Thank you so
Bye.
much.
Thanks a lot.